that this committee has adopted. So in answer to the question, is the motion appropriate tonight, the answer is no.
May I speak on behalf of Mr. Felkner on that issue?
Could I?
Now that you've addressed that issue,
well,
Madam Chair.
I think he's not done.
Okay, thank you.
Thank you. I would like to very briefly address some of the other issues that have been raised tonight. First of all, with regard to the issue of the doctrine of incompatibility, with all due respect, there is an incompatibility here, and that is pursuant to the Chariho Act. The Hopkinton Town Council can vote to withdraw Hopkinton from the act. That is where the incompatibility arises. The very essence of Chariho as a district is subject to the action of the Hopkinton Town Council. The Hopkinton Town Council at its next meeting can vote to withdraw from Chariho. There are certain conditions that are placed upon that, but it's up to the council to make, the Hopkinton Town Council to make that decision. So in fact, the two offices are incompatible. In addition to that, service on the two is precluded by the explicit text of the Hopkinton Town Charter. The last time I checked, no means no. Now, with regard to, let's just let Mr. Felkner sit here. I wish that life was so simple. I do agree with Mr. Gorham that the place to get an answer to this is in a courtroom. However, the only person who can bring that action in court is Mr. Felkner or the Attorney General of Rhode Island. That is based on the Rhode Island Supreme Court's decision in 2005 of McKenna versus Williams. The court made it very clear there is only two people who can straighten out this matter. One is Mr. Felkner, and Mr. Felkner, if he brings the action, it goes straight to the Supreme Court. Do not, wait around, don't delay. It goes straight to the Supreme Court. The other option is the Attorney General brings the action. That would go through the Superior Court and then possibly to the Supreme Court. But Mr. Felkner can end this by going straight to the Supreme Court. In terms of timing, the Rhode Island Supreme Court rules on election matters very quickly. We've all read in the newspaper questions about recounts in West Warwick and so forth. When the Rhode Island Supreme Court needs to make a decision, and in an election case, they know that they need to make a decision. I am very comfortable that we would have an answer, frankly, from the court by our January meeting. The only person who has to initiate that, however, is Mr. Felkner. Now, what's being offered to you tonight, and it sounds so easy, is, well, let's just have Mr. Felkner sit here while we're figuring this all out. There are two problems with that. First of all, the public is harmed by that. And the reason why the public is harmed by that is because, as you just did earlier this evening, you meet in executive session. And there is information that comes up in executive session that you as school committee members have a right to ask about. We just spent the last 45 minutes talking about particular students and particular cases. Now, the superintendent, in an abundance of caution and courtesy, chose not to use those children's names. And all these cases but one are cases where the parents have filed complaints against the school department. But I'm going to bet money that there are people at this table who can figure out exactly who we were talking about. Because let's face it, this is Rhode Island and everybody knows everybody. Those parents and their children have a right to privacy that you are obliged to protect. And if I was one of those parents, I wouldn't want somebody who may or may not be a school committee member sitting up there and listening about my information. Second thing is, it goes back to the Supreme Court decision, the process. If Mr. Felkner is seated on the school committee, you know what the Supreme Court is going to say? Well, you decided it. You let him sit on the committee. There's nothing for us to decide. Case dismissed. The only way that this can be brought to a resolution is for you to honor the decision that you made at the last meeting, which is not on the agenda for a vote tonight, and then it's for Mr. Felkner to bring a petition, the legal term is called quo warranto, before the Supreme Court. I will also make the commitment here that whatever it takes to expedite the schedule before the Supreme Court in terms of turning around briefs, turning around papers, and so forth, I am committed to do that. Because frankly, I agree very much with Mr. Gorham. We need to get a resolution. We need to get a resolution in court. Thank you.
May I address briefly?
I think there were 5 points made, so I'm going to go through them as quickly as I can. The first one was, I don't know all your bylaws and everything. I be perfectly candid. I don't know what your rules say about what you can do with a reconsideration. I mean, I learned in the General Assembly the hard way most of the time that the majority rules. But if you could consider removing him from the committee at your last meeting, how on earth can you not consider or reconsider putting him back tonight? It's on the agenda tonight. I mean, I'm lost on that one. Completely lost. Okay? That's just basic fairness. That's basic logic. Number 2, incompatibility. It's supposition. Suppose it comes up that Hopkinton wants to withdraw. Pure supposition. That's it. That's the whole case. Rhode Island says it's insubordination. That means you can't be the town clerk or the town chief of police and be the president of the council or a member of the council. Or, as Rhode Island has specifically done, you know this, I'm sure you know this, you can't be a teacher at Chariho and be on this committee. That is incompatibility. And it's codified in the general laws. The AG and Mr. Felkner are the only 2 people who can do that, make that declaration. Why on earth did you do it? Prejudice. I went through that. But consider this talk about your executive session. You know, I learned in the last election on November 4th, we're all going to leave the legislative bodies we serve at some point. We take all that information in our head. You're all going to leave. He's gone. You're all leaving at some point unless you're absolutely crazy and you want to stay here forever. But you're all leaving at some point. So you can't unring the bell. The question is, should you let him stay in the room while you're talking about whether the bell should be rung? That's all. You can't unring it once it's rung. He's going to be in those sessions just like you are. The question is it fair to let him sit there while you're deciding whether under law he should? But remember one thing. He's got the gold standard as far as his entitlement to be there. He got elected twice. So that to me is the gold standard. That is why he should be there. That is the number 1 reason he should be in the room. And finally, the notion that he shouldn't return until he gets a judgment from a court saying that he can. Imagine if we did that for criminal law. Sorry, you have to stay in jail until you prove your innocence. That's just not right. We all know that. We know that's not right. And I think in your heart of hearts, I believe that every one of you knows that the right thing to do and the fair thing to do tonight is to just let him serve until